go ahead and have a seat. We are next taking up the case of People of the State of Michigan versus Robert Nelson Jr. This is file number 26-14199FH. Appearances from counsel, please.
Lisa Dole for the people.
Good morning, Your Honor. Allison Cass on behalf of Mr. Nelson. I believe Lynn Getz might also be in the waiting room.
Pam says yes. Let's welcome her in. Oh. There we go. And Miss Lynn Getz also joins us from the same defense attorney's office, and Mr. Nelson is here in the courtroom. Now we are here today for, looks like a probation violation sentencing and a pretrial agreement. Let's go ahead and talk about the pretrial agreement on this new file. Yes, ma'am.
Your Honor, there was a global resolution agreed upon by the parties and proposed to the court. Mr. Nelson would be pleading to use of a controlled substance, count 2, in case 2614199FH. We would dismiss count 1, possession of an analog, controlled substance, second or subsequent offense notice, and also habitual fourth. He has previously already pled to the probation violation in case
24-13814F8, which I also call at the same time. Thank you.
Yes, Your Honor.
All right, Miss Castle, I assume you're going to be the one doing the talking today. Is that a complete and accurate statement of the pretrial agreement to resolve file 199?
Yes.
Thank you.
Your Honor, I really apologize for interrupting, but there was one more aspect to the global agreement. It was that the people were not going to file the assault and battery charge. That was pending review. That was one of the probation violation charges. I apologize for not getting that.
All right, Mr. Nelson, have you heard what these ladies have told me today?
Yes, Your Honor.
Is that how you wish to resolve this other file?
Yes, Your Honor.
All right, thank you. Please raise your right hand the best that you can. Sir, do you swear or affirm that the information and testimony you will provide shall be the truth, the whole truth, nothing but the truth?
Yes, Your Honor.
Thank you. You may lower your hand. All right, sir. So in this newer file, I understand, and obviously we've already dealt with the fact that you were on probation when it occurred, and we've already dealt with that prior probation violation. So in this file 14199, you are currently charged with a single count of possession of the controlled substance amphetamines, which is an analog, not methamphetamine, but amphetamine. Well, that's a felony punishable by up to 2 years and or up to $2,000. Plus, there are 2 potential sentencing enhancements that could increase those maximum punishments within the discretion of the court if you were found guilty of those. A second or subsequent drug offender enhancement could increase that maximum punishment from up to 2 years to up to 4 years, and from up to $2,000 to up to $4,000. Or the alternative, you could be sentenced as a 4th habitual felony offender. That would allow the court within its discretion to sentence you up to 15 years instead of 2 years. However, that count, possession of possession of amphetamine, and the 2 enhancements will be dismissed if you enter a plea of guilty to, and I accept that plea, to an added count 2. Added count 2 would be use of that controlled substance, which is a misdemeanor punishable by up to 1 year and or up to $1,000. Is that what you understood you were doing today?
Yes, Your Honor.
Now, entering a plea of guilty to this added count 2 means that you will not have a trial. Does that make sense?
Yes, Your Honor.
If I enter that plea, if I accept that plea, again, you'll be given up these certain rights: the right to be tried by a jury, the right to be tried without a jury if you chose, the court and the prosecutor consented, the right to be presumed innocent, the right to have the prosecutor prove your guilt beyond a reasonable doubt, the right to have the witnesses, the right for you to question and cross-examine any witnesses who appear against you, the right to have the court order any witnesses you need to appear for your defense at the trial, the right to remain silent at the trial, the right to not have that silence used against you, and the right to testify if you chose to testify. You understand those rights?
Yes, Your Honor.
And even more importantly, you understand that by pleading guilty, you'll be waiving those rights and not have a trial in this case?
Yes, Your Honor.
All right. Leading me to believe that I missed one of the rights. Just to my head. Actually, The right to be presumed innocent until proven guilty, the right to have the prosecutor prove you're guilty beyond a reasonable doubt. Right to have the witnesses against you appear at the trial, the right to question and cross-examine those witnesses. Again, you understand all that?
Yes, Your Honor.
And again, you understand that if you enter a plea of guilty, you'll be forever waiving those rights as they apply to this particular case.
Yes, Your Honor.
Also, you'll be, any appeal as to the conviction and sentence pursuant to the pretrial agreement would be by filing what's called an application for leave to appeal and not an automatic or claim of appeal by right, which is only allowed when you're convicted at a trial. Furthermore, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. You also will be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me today on the record. Have there been any other promises, threats, or inducements that we haven't talked about?
No, Your Honor.
Are you entering the plea of your own free choice?
Yes, Your Honor.
Now, throughout this process, have you been able to speak with Ms. Castles or Ms. Getz?
Yes.
Have they answered all your questions?
Yes, sir.
Are you satisfied with their advice?
Yes, sir.
And do you believe that this plea is in your best interest today?
Yes.
Has anyone made any promises to you as to exactly what the sentence would be in this case?
No, Your Honor.
All right, thank you. Do you still wish to enter the plea as we just discussed?
Yes.
As to added count 2, use of the controlled substance, amphetamines, and analog, how do you plead?
Guilty.
Before the court can accept that plea, I need to have you tell me what you did that makes you guilty of the offense. Looking back on a certain date, that would be July 1st of last year in the city of Cadillac here in Wexford County. What happened here?
I possessed a backpack that carried some utensils that had this substance.
Okay, and you knew it was there?
Yes, Your Honor.
And did you have in your mind any lawful right to possess that substance?
No, Your Honor.
Did you, again, you knew, you already said you knew it was there, and did you use it on or about that date or time?
Yes, Your Honor.
All right, thank you. Ms. Dahl, do you believe the defendant provided a factual basis?
Yes, Your Honor.
Are you aware of any of the promises, threats, or inducements?
I know.
You believe the court so far is in compliance with the court rule 6.302.
Yes, sir.
Ms. Cap, hold on. Ms. Getz, Ms. Castle's doing all the heavy lifting today. Do you agree with all those answers from Ms. Dahl?
Yes, Your Honor.
Great, thank you. If you're gonna have two attorneys, they may well both be involved. So, all right, the court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the elements for that added count 2. Therefore, the defendant is found guilty of that added count 2, and count 1 and the enhancements will be dismissed upon sentencing. My intent here is to likely just sentence with time served as the offense that I just took the plea for, and then move to the sentencing on the probation violation. The only reason I would do send it back and do another sentencing date would be if I was gonna give them probation. But if I have it run currently, then it's gonna be served. So, Ms. Dahl, any objection to that?
No, Your Honor.
Ms. Castle, we'll go back to you. Any objection to this process?
No, Your Honor.
All right, so now we're gonna look here at file 13814, and we're looking at this probation violation report, which is also known to us as a CFJ 491. Ms. Dahl, have you taken a look at that report? And if so, do you have any corrections or objections that you think you need to put on the record?
I have reviewed it, Your Honor. I don't have any corrections or objections.
All right, Ms. Dahl, Ms. Castles, have you had a look at it? And if so, do you have any corrections or objections to make?
No, Your Honor.
No, thank you. Then let's go to allocution, and we'll turn to the people. Ms. Dahl, the floor is yours.
Your Honor, I'm coming into this case a little bit late. My involvement in this case has been the probation violations. The court is obviously aware of this case from the start. So but based on my review of his conduct on probation, his committing new offenses, him absconding, I don't believe he is a good candidate of probation any longer. He's had multiple violations. His guidelines are 10 to 23. Case, I do believe the court has justification based on his performance on probation to go outside of the guidelines and give him more than that if the court chose to do so. But people are asking that he be sentenced to 23 months in prison because the court has given him chances of probation and giving him an opportunity to get help, get treatment, get better, and he has continued to violate the court's orders. So I believe a prison term is appropriate in this case.
Thank you. Ms. Castle.
Thank you. Your Honor, I would like to start by making note of the fact that Mr. Nelson has taken accountability for the mistakes he's made while on probation by entering the plea in this case that he just pled to. He's showing that he is admitting to it and he does firmly want to get better. He is expecting this prison term and he wants to make the most of it. He has plans for programming. I would like to note that he does have credit for 224 days. And based on this, we believe that it should be something within the guidelines, likely at the 18-month mark.
All right, thank you. I should also recognize Mr. Charles Kennard from the Michigan Department of Corrections. That office is the one that prepared the pre-sentence investigation report. Just a quick look. All right, thank you. Mr. Nelson, you have the right to make a statement before the court issues a sentence. Is there anything you wish to say at this time, sir?
Your Honor, I think I have a little bit more than 300 days served.
At 324. Yes, sir.
I would be getting credit for them. And then,
If you want.
of course, sir.
Anything else?
No, Your Honor.
All right, thank you. Mr. Nelson. This case originally involved a possession of methamphetamine case. And the court gave you 36 months of probation, 300 days in jail. And then it gave you the opportunities at rehabilitation, and there was an absconder response. This is just that challenge. I spoke yesterday at a drug summit, a rehabilitation summit out at Baker College, and we talked a lot about treatment programs and how many cases involve controlled substances and the opportunities and how difficult it is for people who are struggling with substance use disorder. And so I'm not here to say today that you're a bad person for this offense or even some of the probation violations. It's just a symptom of the disease and how it spreads. At the same time, there's always a discussion about what do judges do. Do they give jail? Do they give probation? Do they give rehab? Do they give prison? And the answer is sometimes it's got to be a prison term because all the other efforts may have failed or they may not have worked. I don't like that word failed. So there are opportunities that were unsuccessful. I'd rather use that word. Failing sounds really negative. And I don't like calling it a problem. Old substances, drug addiction, things like that locally, they are opportunities for people to try to help. People mean the courts, programming, even prosecutors and defense attorneys will often work together to help get a person into a rehab program. It's opportunities for us all to help those who are struggling with that issue. And I know that when somebody is under the influence of a controlled substance or even alcohol, they're not always in control of what they're doing, or at least it impacts them and changes them. So I don't want you to think that I look at this and say, oh my gosh, Mr. Nelson's the evil person here, but you're struggling. I don't know what else to do. We've had a lot of opportunities here, but I hope that you continue to find opportunities. Sometimes prisons, they've got rehab programs, they've got trades, things like that. I know it's not great, but I really want you to know I care. I really hope that someday you come back here to the office and say, hey, Judge, I did one. I need help. Where do I go? I'll tell you where to go. I'll help you get there. And I also hope that you come back and say, hey, Judge, thank you. You don't have to say thank you because no one likes us to be sent to lock up, but I want to see that you come back. You got a lot of life here to live. Pretty sure you're younger than I am. So, all right, anyways, I really hope that you get this figured out. All right, in file ending in 199, the court sentences the defendant as follows: a $50 state minimum fee, a $75 crime victim right fund fee, a $150 court cost, a $150 attorney fee. There's no supervision, therefore there's no supervision fee. I'm not going to assess a fine. And the court sentences the defendant to 38 days with 38 days of credit. The arrest didn't take place or wasn't counted until January. I think it might have been the 16th or whatever. So I'm just giving you credit. That sentence, therefore, will run concurrent, but in effect, it's already been served. The old case. Now, in the older file, the one for which we're here talking about this probation violation, which is file 13814, the court revoked probation unsuccessfully. The court preserves any unpaid fines and costs, and the court sentences the defendant to a prison term that will be 20 to 120 months. And the court, of course, gives the defendant jail for credit, which is 324 days. Now, that only accounts for the days that you've actually sat in jail. It doesn't account for any good time credit, which you get to keep, and that will be added to that amount. All right, so it's not just 324, it'll be higher than that. If you serve 300 days before, for example, it should be a number of days. Anything that I've missed, Ms. Dahl?
Not that I can think of.
How about you, Ms. Castle?
No, Your Honor.
Ms. Getz, how about you? Do you think I get it all?
You got it all again, Judge. Thank you.
Mr. Kennard, anything that I missed?
No, Your Honor, thank you.
Samantha, do you have an advice and rights form over there? There should be a new one signed by the defendant. Normally there would be on there to get printed. So, Ms. Castles, Ms. Getz, you were on the monitor here in the courtroom right above Samantha's head. Samantha's new at this job, so if you could all just like look down, kind of like in the Brady Bunch there, see, now they're looking down at you, Sam. You feel the pressure?
Yeah.
All right, ladies, thank you. You don't need to look down. All right, so if we don't get it to you right now, Mr. Nelson, somebody will take care of it, probably somebody from the Department of Corrections. You have the right to appeal your conviction and sentence in this case. That is done by filing a claim of right, an application for leave to appeal because of the original plea and guilty. If you choose to file an application for leave to appeal and you want the court to consider appointing an attorney to assist you, you will complete a copy of this document that we are hoping to get to you here today and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. Do you have any questions about your rights to appeal?
No, Your Honor.
Do you have any questions about what we have done today?
No, Your Honor.
All right, Mr. Nelson, let's look at this as an opportunity. All right, thank you. We're good.
Have a great morning.
Thank you, ladies. Nice to see you all. We're good.